Hi, just another update on logistics. So apparently room 74 is full, but now room 64 is available for those of you who are standing and would like to take a seat. Thanks so much. We'll get going in just a minute. Up on the screen, just because we don't have that much time today and we have a lot to discuss, I'm going to give rather brief introductions to our distinguished panelists. But because they're so accomplished, if I went through all their qualifications, we'd use up all the allotted time. So we've put it up here on the screen, at least two, and then, oh, there's the other two. Okay, great. Well, now that I'm talking, I might as well just keep going. So thanks everyone for coming and coming to this very timely and topical panel, which is part of the McKercher LLP lecture series. And McKercher LLP, we want to give special thanks, has been sponsoring this lecture series for, I believe, 4 years now, allowing us to bring a wide variety of lectures to the college, delivered by informative, entertaining, and educational speakers. So no pressure on the panel, but that's what you can expect. My name is Jason MacLean. I'm a faculty member here at the college, and I'm going to be the moderator today for our discussion on pipeline politics. We're going to be talking about the Federal Court of Appeals' recent decision in respect of the Trans Mountain Pipeline expansion, about environmental assessment of major projects, and in issues with respect to the intersection of environmental assessment, the duty to consult, free, prior, and informed consent, etc. As we gather here today, we acknowledge we are on Treaty 6 territory and the homeland of the Métis. We pay our respect to the First Nation and Métis ancestors of this place and reaffirm our relationships with each other. So the brief introductions. To my immediate left is Sara Mainville. She is a partner at OKT LLP in Toronto, specializing in Indigenous law and Indigenous governance. She's actually the only member of our panel who's not a graduate of the College of Law. So that's why she's gonna, so we have to welcome her, and we'll give her the honor of speaking first. Next to her is Devon Page. He's the Executive Director of Eco Justice, Canada's leading and largest environmental charity and law firm, and graduate of the college. Next to Devon is Bernie Roth. Bernie's a partner at Dentons LLP in the Calgary office, specializing in environmental and energy law and a number of other areas of law, and also a graduate of the college. And farthest to my left, geographically, is Professor Dwight Newman. Distinguished professor here at the college and also a graduate of the college. So the way we're going to work, I'm just going to give you a brief rundown of the logistics, and then I'm going to shut up. We're going to go through two initial rounds. In the first round, each of the panelists is going to speak for no more than 4 minutes, making the main point that they want to make. Then we're going to do a second round immediately thereafter, during which each panelist will speak for no more than 2 minutes. Then I'm going to pose a couple of questions to the panel as a whole, and then we'll open it up to you for audience discussion. So without further ado, please welcome our distinguished panelists and enjoy the discussion.
Miigwech, and thank you. And I'm from Queen's Law, so forgive me for that. I'm going to introduce myself in a traditional manner. Buju, Kabamishit Pinisikwe, Indigenous Makwa, Dodem, Kuchiching Nindoji. I'd like to also acknowledge that we're in Treaty 6 territory in the homeland of the Métis Nation, and also honor Wiwin Mika Wap, the spirit name of this law school. And when you give a spirit name, you invite in the spirit of that particular teaching, and so as being part of a law lodge is something that I've always aspired to do, and you know, being part of a Cree law lodge is amazing opportunity for all of the students here at Saskatchewan. In the early days of consultation, I remember hearing that now that there was a right of judicial review to protect Section 35 rights, governments would no longer make decisions. I think that was a joke. So the Crown governments, like all governments, that's what you're in the business of doing, right? Making decisions. And you have to remember that with Indigenous governments. I'm a member of an Indigenous government that existed long, long before Canada came into being. And we make decisions. We say yes or we say no. And courts in this country, courts review those decisions. And that's how we make sure that we're being fair. And the duty to consult comes out of the common law because Crown governments have not been fair regarding protecting Section 35 rights. There's a phrase that I've come to see more and more in the media, like a promise made to the Indians. I don't know if you've ever seen that on Twitter or elsewhere. Like a promise made to the Indians. As if legal obligations to First Nations people, Indigenous peoples in Canada, is not a thing. And that kills me. Prime Minister Trudeau said that the pipeline will be built, but he also said that Indigenous peoples, the relationships with Indigenous peoples in Canada, is the most important relationship to Canada. How do we reconcile that? Well, we reconcile it through law. Not just Canadian law, but also Indigenous law. That's the work that I've been doing with the Assembly of First Nations, the work that I did with my friend at the back of the room, Carl Vermette, on the MIAC committee, advising during the EA panel review and afterwards to create Bill C-69 to try to inform Canada that its jurisdiction is not the sole jurisdiction around development in Canada. Indigenous law also has to have room and space to do the good work that it's meant to do. And so that's one of the main points that I want to make today. I want to talk a bit about the duty to consult, but I also want to talk a bit about free, prior, and informed consent as well. And I also want to make sure that everyone realizes that this is all about governments making decisions, not in watertight compartments, but cooperatively. And cooperation is the promise of Canada. Cooperation is why Section 35 exists. My thesis has always been that Section 35 exists so my way of life can coexist with the Canadian way of life. And Trans Mountain is definitely a very, very important reminder to all of us that this is something that we need to get right. Not the second or third or fourth time around, but the first instance. We need to all talk to each other. You need to learn about how my law works, as well as how Canadian law works. And we need to be able to share and work in partnership. That's the promise of treaties. And I understand that through my own understanding of my treaty, Treaty 3. So we can't just, can't create an afterthought of consultation. And that's what happened in the Northern Gateway case. It's now happening with Trans Mountain. And they'll try to create another process, hopefully in partnership with First Nations that are impacted, that actually truly tries to accommodate the First Nation rights, interests, and concerns in a real way if this project is going to go forward. And I really, really also want to underscore free, prior, and informed consent means that we have the right to make a decision. It might be the wrong decision, but I really respect the fact that some First Nations are actively in discussions about pipelines and projects and trying to make a really important decision for the future and sustainability of their communities. And I respect their self-determination rights to say yes when I think maybe they should say no. I respect that, and I think we all should. Miigwech.
So from my perspective, the pipeline issue we face, wrapped up with an environmental issue on Sara, species at risk, environmental impacts, consultation issues as they affect pipelines, really driven around the climate change agenda. Starting quite a few years ago, probably in the mid-2000s, finally manifesting itself with the Obama administration's decision in Keystone XL to stop the Keystone XL pipeline, was in large measure, completely, his reasoning was climate change. I'm stopping it was climate change. Extremely ironic, given that when he came to power, the U.S. was producing about 5 to 6 million barrels of oil a day, and at the time he killed Keystone XL, he was almost doubled that up to close to 10 million barrels a day. North Dakota was producing over 1 million barrels a day, flaring and incinerating gas that had a larger carbon footprint than virtually any Canadian production. But somehow the idea resonated with environmental groups. You couldn't stop production in the field, by and large because there's free, prior, and informed consent in the field. Up in the oil sands region, virtually all First Nations are commercially benefiting. They are saying yes to these projects. Their traditional ways of lives depend on these projects because they provide employment, opportunity, and income in their communities to subsist. The environmental movement attack pipelines further away. They don't come up to Fort McMurray. They don't attack them in southern Saskatchewan, and they don't attack them in southern Alberta or northeastern Alberta. They attack them where they're most vulnerable, on the west coast, the east coast, and the United States. And they have politically and legally succeeded. Politically, they succeeded in killing Keystone XL. Politically, they succeeded in killing Northern Gateway. And politically, they succeeded in killing Energy East Pipeline. So what are the economic consequences of that? What are they to communities, First Nations communities? They are economically devastating. Canadian oil is trading for half of the American price right now. To give you an idea, that is millions of dollars a day, billions of dollars a month, and tens of billions of dollars a year. To give you an idea of what WTI trades for, $70 and change, Western Canadian Select is 35 bucks. There's a little bit transportation differential in there, but the economic equivalent of that to Canadian provincial governments, the federal government, and Canadian producers is equivalent to about a carbon tax in the range of $300 to $500 a ton. That's the economic equivalent of this. So my suggestion is we're facing an economic crisis right now because of political decisions and some administrative law decisions leading to the overturning of the TMX approval. In times of economic crisis, Parliament should act. Parliament can act fairly. There's an issue as to whether or not, and it's before the Supreme Court right now, Parliament owes a duty to consult. But on the Aboriginal question, the consultation, the court didn't have a problem with the hearing of the concerns of Aboriginal groups. The time was spent. Their problem is nothing was done about it. Parliament can intervene now, very quickly, put the certificates back into place, and put the conditions in place that are responsive to the Aboriginal concerns. With respect to the southern resident killer whales, Parliament can put speed limits on traffic in the Port of Vancouver. It's not that pipeline project or the associated tanker traffic that is causing problems with the southern resident killer whales. It's their loss of habitat, no salmon to eat. It's the existing risk of tanker collisions. The federal government in various departments knows how to fix the problem. Parliament could act conditions to address those issues and deal with this back and forth that happened between the NEB and the governor and council, saying we can't accommodate these concerns because we don't have jurisdiction, only the NEB does, and the NEB tossing it back saying we don't have jurisdiction. So we are in a time of considerable economic crisis affecting First Nations, affecting you as far as there's not going to be a whole lot of jobs in Calgary for lawyers unless we get our pipeline problems fixed. The career I have will not repeat itself. I always put it when I talk to my kids and they're having environmental debates with them, if we accede to radically cutting our emissions overnight, we're moving back to Saskatchewan to the farm, because you cannot sustain a population of 3.5 million people in Alberta without an energy industry. And unless we get our things sorted out, we are at a very difficult time right now. Dwight? Oh, sorry.
I'm struck these days by the notion of miracles and catastrophes, and I'm just going to try to apply that concept here, and you'll be the judge of whether it works. But the description was first applied by George Monbiot. He's a UK Guardian journalist and author who described the Paris Agreement in 2015 as a miracle and a catastrophe. A miracle in that world leaders assembled and actually identified a meaningful target to reduce greenhouse gases to address climate change. A catastrophe in that, once again, there was no implementation mechanism or enforcement. A more recent miracle, our victory on behalf of two environmental groups, Raincoast Conservation Foundation, Living Oceans Society, at the Federal Court of Appeal, that the court sided with, that said that the National Energy Board had failed to consider the marine impacts of project-related shipping. Everything my friend said on the killer whale is correct. The one piece that is, I think, informative, it certainly was at the National Energy Board, is that the evidence currently before the National Energy Board that's uncontroverted is that the additional shipping occasioned by the tankers will increase the risk of extinction by 50%. The catastrophe is the environmental context. So it is, as my friend described, those species are internationally iconic. And people go out to the West Coast to watch them swim and cavort. And they swim through sewage, literally. They're starving. And the tanker, all the boat traffic, interferes with their ability to echolocate and find prey. So they're on the brink. But the greater catastrophic message is that they're just an example. They might be one of the worst examples, and I don't want to overstate things. But there is a description right now that Canada is on the verge of a biodiversity collapse. So a 2016 report that tracked for 30 years the populations of 900 species that are tracked in Canada to determine the health of biodiversity concluded in 2016 that 1/4 of them were depleted by 83%. 1/4 of Canada's tracked biodiversity is now on endangered species list. And the thing that we should start to appreciate is that's so far-reaching, that's every day. So I looked up the Saskatchewan species of risk list, and I had no idea. But sparrows and barn swallows, now on endangered species list for Saskatchewan, something formerly ubiquitous. Another miracle. Justin Trudeau comes back from Paris and proposes a pan-Canadian framework on climate change that has a meaningful target. An additional miracle. Alberta is the first signatory. Well, what's the trade-off? Well, they agreed to a cap on tar sands emission, which is unbelievable. But the cap is 100 megatons, which allows for substantial growth. And to get that agreement, he had to promise a pipeline. Now, the catastrophe is Canada's performance on GHGs, on climate change. Among the industrialized nations of the world, there's no country that's worse than Canada when it comes to per capita emissions of GHGs, with the exception of Australia. When you look at global total emissions of carbon, we're ninth. Now, ninth isn't first, it's not second, it's not third, but we have a minuscule population relative to our peers. And when you look at the tar sands relative to Canada's production of GHGs, it's about 10%. We're currently there's one more tar sands mine that's being reviewed. We're before the National Energy Board. I think the hearing starts next week. And the evidence so far that's uncontroverted is that if they continue to grow the tar sands, there's no way Canada can meet its climate commitments unless we shut Ontario down. Now, the last piece I'll say in the issue of catastrophe is there's a forthcoming report coming from the UN Intergovernmental Panel on Climate Change. And I think it's a good thing that they've stopped pussyfooting around the issues. So what they've said is, if we don't decarbon the economy by the mid-century, it's calamity, it's catastrophe. It's what you're seeing in North Carolina, South Carolina now. It's what you're seeing in Ottawa. And, I think of the mayor, and you might have seen this fellow on the news this week. He said, geez, we've had our second once in 500 flood in a year. Geez, maybe there's something to this climate change. When are we going to do something about this? The risks posed by climate change far outweigh the short-term economic benefits by producing dirty oil.
So I'm going to speak briefly to how the Federal Court of Appeal decision in Trans Mountain is yet another example of how the Canadian regulatory process, broadly conceived, is struggling to provide regulation that achieves the various values that one expects from the regulatory process, thinking particularly of the context of major transportation infrastructure projects like pipelines. And by the regulatory process broadly conceived, I want to note that the court's years of subsequent analysis on decisions within the regulatory process narrowly conceived are now effectively part of that process. So approval of a major pipeline project now proceeds not only through years of community engagement, years of hearings before an independent regulator, and a political process at the federal cabinet, but then must also face a gauntlet of subsequent judicial analyses, along with perhaps the interference of further governmental entities that have no jurisdictional basis to be involved, whether the mayor of Burnaby or the mayor of some small town in Quebec. Even the simplest of judicial analyses is slow going within the not entirely efficient Canadian judicial system, so years are added on before the final decision that may shift a prior approval to a suspension and a period of further analysis. In terms of the values one would expect from a regulatory process in this area, I think one would look for, first of all, efficiency, clarity, and certainty of decision making. Second, safeguarding of the public interest generally. And third, protection of specific legal rights insofar as they take priority over the general public interest, although in doing so, we could reasonably call them part of that public interest at the same time. And I'm thinking there especially of Indigenous rights. The particular combination of systems involved have led toward a situation where the Canadian regulatory process in the pipelines context is arguably struggling on all of these fronts, although there's complicated things to say that the 4-minute time limit won't permit. But first, in respect of the question on efficiency, clarity, and certainty, specific procedural values that one expects of a process, that's probably the easiest question to answer. The process, broadly conceived, has now become an utter mess. From what could have looked like an official approval of the project within the known regulatory system in 2016, granted after the project proponent had spent hundreds of millions of dollars getting through that process, matters on Trans Mountain ended up at fall 2017 court hearings and a fall 2018 court decision that quashed the whole thing. From the standpoint of those who would build infrastructure in Canada, there are increasing statements that Canada, with this regulatory system, has become uninvestable. That in itself will have implications for the country's employment and funding for public services in the years ahead. Second, there's a big question of to what degree the regulatory process is or isn't safeguarding the public interest. And that's a more complex question than we can answer quickly on one panel. There are obviously always complex trade-offs of economic factors and environmental factors in decision-making about these types of projects. We do have what was meant to be an independent, fact-based regulatory process in which the National Energy Board has routinely added even hundreds of conditions onto pipeline projects to strike what it considers optimal balances. The proposed new system in Bill C-69, of course, affects some changes, and there are arguments each way on what it will or won't achieve. There are big questions at stake there. A third question pertains to the specific rights held by individuals or communities that have constitutional priority, notably rights held by Indigenous communities. There are various challenging questions here and real uncertainties. Some rights claims are advanced at different levels of communities in different ways, and there's allowed to be disagreement within Indigenous communities or as between different Indigenous communities, just as there is amongst non-Indigenous communities or within non-Indigenous communities. That's not a surprising thing, but it gets legally very messy. Some communities have seen what they see as their rights to pursue economic development squashed by other communities' rights to further consultation, but we could add vice versa. The Federal Court of Appeal analysis of what it says was a bungled political process in the latter part of 2016 between the NEB conditional approval of Trans Mountain and the cabinet decision would say that the government has failed to understand some very fundamental points about meaningful consultation and the options available to it at the cabinet decision-making level. That same government has policy and legislative initiatives underway where it purports to be following even stricter standards that it would suggest are embodied in the UN Declaration on the Rights of Indigenous Peoples. How it will do so when it seems unable to grapple with even existing legal requirements within the Canadian duty to consult doctrine is somewhat of a mystery to me. Make no doubt about it, the Canadian regulatory system is struggling in a number of ways, particularly in this context. It's escaping the attention of many, but Canada's in a very challenged state around these issues.
So I think we have 2 minutes to not necessarily debate the issues that came about, but I want to share some of the practitioner perspectives about consultation and Indigenous peoples for the future practitioners in the room. So to be clear, this is not necessarily a consultation law case. It's about the implementation of a consultation program. And to be clear, the Court of Appeal felt that the process was enough, but the implementation or the execution of the consultation wasn't enough. So for Indigenous peoples, this is a bit of a sour win. And to be clear, as Indigenous practitioners, we're not anywhere near where we want to be as far as government working with us cooperatively to ensure that developments take into consideration Indigenous rights, Indigenous title, and Indigenous concerns. So there's a major worldview issue here. And if you look at Indigenous Twitter or social media, you'll see there's a great big gap in ideas about what's reasonable under the circumstances. And you see certainly there is a divide that's happening even with one of my clients, Assembly of First Nations, and other folks that I work with, the so-called grassroots, or people who are involved in Idle No More, that really want to demonize what's happening at the Assembly of First Nations. I had the opportunity to help the regional chief, Kuania Adamak, make submissions on Bill C-69. And it was a bit uncomfortable because we were upholding what we thought was environmental and constitutional standards, but we were also doing our presentations at the same time with First Nations who are very much involved in the Trans Mountain process, Alberta First Nations, some BC First Nations, and it was the divide was very stark, and reconciling that is really something that's an important conversation that Indigenous peoples have to have in order to ensure that we are, in fact, respecting the communities, the sovereign community's right to decide yes or no. So there's some, I'll get into more when we have more questions and dialogue about some of the aspects of the consultation regime that you should note that's important guidance that this court and other courts have given about ensuring that you have a dialogue with First Nations, and that you actually don't just act as if the court said as note takers, but you actually try to do something about the concerns. And we can talk about that more in future rounds.
So I'll start with the issue of Aboriginal consultation and accommodation. And just to point out, Project Northern Gateway had support from 80% of the Indigenous population affected by the project, 60% of the actual organized groups. TMX did better than that. At the end of the day, TMX confronted 6 out of 80 Aboriginal groups. The vast majority had benefits agreements, were looking forward to the benefits of it. A project like TMX, in the national interest, should not be stopped by one province, one city, or 6 First Nations. The Indigenous population, vast majority of which supported the project. So free, prior, and informed consent for everyone means no one gets anything done. As far as the environmental movement and the climate change agenda and species diversity is concerned, just a point on the 50% increase to the extinction of the southern resident killer whale. That may have been the evidence before the tribunal. It certainly wasn't the conclusion that the extinction was increased by that amount. But one of the problems and the reason the court turned this around is because they assessed unmitigated impacts. They didn't look at mitigation measures. A project like Northern Gateway that did scope it in found no significant adverse effects on the northern resident killer whale. Reduced tanker speeds. There were no issues with respect to that project. One of the reasons we find ourselves in the position we are, one of the reasons the federal government has paid $4.5 billion for a pipeline, is they killed all the competition. They essentially sole sourced this project to Kinder Morgan, and without a performance guarantee. So they killed TransCanada and Enbridge, the only competition in town, left it to one company, and then let the other company extort them for $4.5 billion. It makes no sense to have killed the projects for political reasons. On the climate change issue, just want to say there's no climate change benefit associated with stopping this. The world will not consume less oil, and jurisdictions with as high or higher GHG emission profiles. This dirty oil thing is nothing but a Trumpism that's been labeled against Canadian oil. Canadian oil is not dirty oil. It's some of the cleanest, most ethical oil in the world, and the world is not going to start consuming less of it. Canadians, First Nations included, Indigenous people, are going to be a whole lot poorer unless we can get our oil to market, our wheat to market, and get a fair price for it.
So I'm a proud graduate of the University of Saskatchewan, so I just want to put a pitch in to someone please join me at some point to become a public interest environmental law litigator, because I think I'm the only one in the community. We're trying to work ourselves out of a job, though, and it's tough. And I guess I'm saying this to impress you, but I was quoted in the New York Times as characterizing Canada's laws as gold rush laws, and in many ways they are. You look at the origins of our environmental laws, what they were about was enabling resource extraction unmitigated. And when our lawyers go into assessment processes, what we try to do is mitigate a foregone conclusion. Canada, if you assess our laws relative to the international community, and the best analysis of that is still David Boyd's book on natural law, we have the weakest or third weakest or second weakest legal regime environmentally. And we're reviewing this in a piecemeal fashion under a weakened regime in Harper. We're the only industrial nation in the world whose laws weakened in the last 10 years. So, yeah, it was a crappy process. Now we're stuck with another 22-week process to review the marine-related impacts. We have no idea what that will mean, but having Justin Trudeau announce immediately after the Court of Appeal decision that they were going to approve this pipeline, we prepare once again for a foregone conclusion.
I'm just going to start by echoing the comment that that the issue in the decision on consultation with Indigenous communities pertained to a problem of execution. The Federal Court of Appeal, the same court that just issued its judgment, issued a judgment in the earlier part of 2016, near the end of the first half of 2016, on the Northern Gateway decision. The federal government purported to try to make adjustments in the last phase of consultation in response to that, in respect then of the Trans Mountain pipeline. But it seems simply to have failed to execute upon that in some ways. And that's the part of the process that the court now pays attention to and says that there was a failure of execution. And so I think we have to ask some questions on what it's really going to get, what it's really going to take to get governments to follow those legal requirements where they've not taken on board the decisions that have come out. And for the future of any kind of endeavor in Canada, this is a really important matter. And of course, there's been reference to their arguments for the law should go further, but the federal government in the latter part of 2016 failed to execute upon the law as it exists now, and that's the decision that the court reached. So it creates a very challenging circumstance where that's what we face. And I think there are a set of complicated questions for governments there. One of the things that the government did do was that it set up a three-person panel out of the Major Projects Management Office to receive additional comment in on the project prior to the cabinet decision. And the result of that was nothing in terms of the consultation decision, because the government set out that that wasn't going to be part of consultation. But that was exactly the kind of process that they needed to be running to meet the expectation of somebody with the confidence of cabinet as part of what the Federal Court of Appeal now says was required. And so we have a situation where the government is taking steps that could have responded to the guidance, but then made a decision that actually led it to not respond to the guidance that they had from prior court decisions. There's an ongoing set of challenges there in terms of getting governments to respond to the court decisions, but I'll leave it there.
Okay, so just to push this our discussion forward a little bit, I want to drill down a little bit on, and this really has two elements to it. So as has been discussed, the government recently announced that the National Energy Board will undertake a 22-week re-review, essentially, of the marine impacts. At a later date, in the coming weeks, the government is going to announce what its next steps are going to be to try and redo what was called the Phase 3 consultation with the affected Indigenous groups. Now, part of the execution problem that the Federal Court of Appeal pointed out in its Trans Mountain decision, as has been noted, is that the government took great notes this time, maybe better notes than it took in the Northern Gateway decision, but it didn't provide any answers. In looking at what, and a lot of the debate and a lot of the misunderstanding, frankly, of the Federal Court of Appeal's judgment in the media in particular, focused on this concept of meaningful consultation. What does it mean? Is it this abstract, mysterious concept? Should the government regulate in respect of it? And going back to the Supreme Court of Canada's decision in Haida, one of the things that the Supreme Court emphasized was that the government, in undertaking consultation, has to keep an open mind. In fact, it's even obligated to be open to changing its mind and changing its plans based on information it gets from the consultation process. So here's my question. We've got a new 22-week process from an agency that's supposed to be independent of the government, and yet the government has been criticizing as inadequate since it's come into office. Following that, or in conjunction with it somehow, is going to be a renewed consultation process. Yet, as Devon pointed out, the government continues to insist the pipeline will get built. How can the government possibly meet its duty of its duty to consult and engage in meaningful dialogue when it's already made up its mind? Anybody?
I can start, because I think that the court has tried to inform the parties going forward. I think that they made a forward-looking decision. And so the critique was there's three major points about the consultation. So during the consultation, there was no dialogue. So the First Nation shared concerns, shared issues, actually shared some accommodation measures that they had proposed. And there was very few responses from Canada. Canada, basically, the representatives took notes and said that they would forward that information on to the decision maker. So of course, that's not meaningful consultation. I don't think any human being would expect that, would say that, yes, that's meaningful consultation. There has to be a dialogue, there has to be a response. There certainly should be some action taken, considering the participation that the First Nations had and the approach that they took, and they tried to provide some solutions. The mandate of the consultation team, this probably led to the note-taking, and the need to have someone with the confidence of the cabinet as part of this process. So a high-level official that actually represents the Crown would have been helpful, and actually that could lead the government to provide some accommodations of the Section 35 rights that were going to be impacted. And thirdly, the discussion around the report was closed. There's no dialogue about the flaws in the report, in the process. Basically, they just heard concerns, wrote them down, and said they would give them to the decision maker. I think that's, again, any human being would reject that as a process, and would reject that as being there being a meaningful dialogue, and so that there should be, the court was pretty clear that the report should have been edited, revised, changed, clarified. Conditions could have been made to meet the concerns of the Indigenous peoples, and that's probably the better approach, hopefully better advised by better constitutional lawyers, frankly, and going forward.
So, Jason, to answer your question, I don't know. But you would have expected that. The one thing that I'll say, and I'm going to defer to Sara, and I have represented Aboriginal clients, but I have no claim to expertise. And I mostly read the decision related to our client submissions. We have a counterpart in the United States called Earth Justice, and they find themselves in a bizarre circumstance of tendering as evidence Donald Trump's tweets to demonstrate that the decisions related to environmental issues are preconceived. I would imagine that same sort of evidence will be filed if the consultation isn't considered legitimate. To me, it looks like there's a foregone conclusion.
Actually, Jason, I find this one of the most frustrating questions, because everybody says, will the project go ahead or not, stop or go, and that's all it is, and they're going to make it go, so it can't be fair. Like it's like plaintiff's bar. You become a lawyer and you're a litigator, and you have people come into your office, do I commence a lawsuit? Like the cases you'll bring and file a statement of claim for, relative to the number of people that'll come in and ask you whether or not they've got a claim, there'll be the vast majority of cases you'll never bring. These applications for big pipelines, the vast majority of the people that come in never bring the applications. The people that are willing to spend up to $1 billion to put it down have a pretty good idea they're going to get the approval at the end of the day. What they don't know for sure is what the conditions are. And sometimes they get a lot of approvals with conditions. A lot of the approvals I get, the projects never go ahead because it's all in the conditions. So I completely agree with Sara. On this, just one as example, and I said Southern Resident Killer Whale. Southern Resident Killer Whale, the federal government essentially abandoned it. I think Ego Justice got some litigation under Sara for an emergency order, at least considering it. But the species is under duress because of lack of food, lack of salmon. They're not populating. That's why it's so critical when one of them gets hit. So the federal government denied the authority to do anything about it. The NEB denied the authority to do anything about it. So there was nothing that was done by way of mitigating conditions. You could reduce tanker speeds on all tankers coming in, tankers, not just tankers, all vessel traffic coming in and out of Vancouver. That would be a huge mitigation step. It would be financially extremely costly for the port and everybody shipping in and out of it. But there are a lot of conditions that could be attached to this. And that's what the federal court was saying. Just no catch-22 here. Not saying, well, I can't do it, and leave it blank. So this project can easily be approved and proceed and accommodate interests of First Nations by adopting many more conditions. And if that had been done in the first place, I doubt that the consultation aspect would have done the proponent in.
I'll just say on this that, I mean, judges get to sit in their offices in Ottawa and say things that in political and practical terms are very impractical indeed. And one of the impracticalities of what's gone on, and I mean, it's all following the law and so on, but nonetheless, one of the impracticalities is that the Federal Court of Appeal takes a year to make its decision and then says, well, government could sort this out in a couple of months. And it doesn't really have all that much practical logic to it that the court itself has to take a year to write a judgment, but they think the government could sort everything out in a couple of months. But this part that would be a basic implication of meaningful consultation, that the government can't say anything on whether the project's going to go ahead or not, is also a very impractical sort of situation, because of course the public wants to know whether the government intends that this project go ahead or not. And it would be an unreasonable expectation in a democratic country to say that the government can't comment on that. At the same time, the government has to act in a way that respects the legal obligations related to the duty to consult. And I think in some ways, if they dialed back some of the statements, it might be enough. If the Prime Minister said that instead of that the project will go ahead no matter what, if he said that the intention is to try to make it go ahead, but that they're going to follow the law, I think that would be a good step forward. But that's not been what the Prime Minister decided to say, so I don't know what the implications are, if he'll follow the law or not.
I've got lots of other questions I could pose to these brilliant panelists, but I'm so impressed with the crowd that we got here, so I want to open it up to audience questions. Yes, go ahead.
Six First Nations communities litigated before the Federal Court of Appeal and opposed it to the end. This is one of the problems with large linear projects, and saying as far as projects in the oil sands are close to, they only affect a few First Nations. You usually can accommodate all their interests. If you end up with a large linear project that crosses 80 First Nations, you can't satisfy everyone. You can't satisfy every province in the country on a political issue, and you can't satisfy every First Nation. So I'm saying at the end of the day, to those that want free, prior and informed consent, if on a large linear project that has 80 First Nations, if everyone has a veto, we're not building anything.
I just wanted to mention that. So the AnyB has a process. So you need to understand the AnyB process. I was actually chief in 2014 of my community when Energy East was a project, and I was downstream of the project, and we were offered, I think, $1,200 to consult our community about the project. AnyB's process is not perfect, and so First Nations have to make the basically the bottom line decision of whether or not it's worthwhile to actually participate. So there might be 80 First Nations that are potentially impacted by a pipeline, but not all of them are going to participate just because of the economics. The other thing is, I think if you look at the applicants, Indigenous applicants that appealed here, most of them had Aboriginal title. I won't say Aboriginal title claims, I say Aboriginal title. That's your law that says that they're claims. My law says they have Aboriginal title. And so they're land governors. They're land governors and have the right to say yes or no whether or not that pipeline goes through. I'm a treaty person. I believe I have co-governance rights. I get to work with the government and as a community member, or sometimes working with political leadership, we have the right to engage and assert our own processes in our own jurisdiction and make decisions. So this veto boogeyman, I think, is not something that helps the discussion. If you're an Aboriginal title owner of land and they want to put a development through your land, you have the right to say yes or no.
Thank you. Other questions? Yes, in the back.
Okay. So for practitioners, I would point to paragraph 563 of the decision. And just to understand that again, consultation is not exactly where Indigenous peoples feel, because we're still in the claims era of Section 35 rights. We still have to claim to Canada that we have these rights, and we have to evidence those claims. That's not where we want to be. But paragraph 563 does give some advice about the dialogue that should have been demonstrated by Canada, not only to be heard, but also to give serious consideration to the specific and real concerns the Indigenous applicants put to Canada, gave serious consideration to proposed accommodations, and there was proposed accommodations, and explained how the concerns of the Indigenous applicants impacted Canada's decision to approve the project. So the importance of decision, the written decisions is really important to this new regime. Hopefully continues to be included in Bill C-69 for impact assessments and for the new Canada Energy Regulator process. But it's important that this idea of government-to-government relationships, that's certainly something First Nation legal counsel should be pursuing, because really that's where you get into the arena of reasonableness. You get into the arena of, as the EA expert report said, yes, there should be a right to consent, but First Nations have to be reasonable in their decision-making process. They have to consider all the information just like any other government and make a reasonable decision just like any other government. And I think that's really, from a practitioner perspective, that you should be thinking as you work with your clients. First Nations are the revitalized Indigenous nations in ensuring that they have a fair, let's show Canada how to have a fair decision-making process for these developments coming into territory that First Nations govern.
Thank you. Other questions?
I do have a question, and someone in the other room asked if you could repeat the question.
Okay.
So that they can hear afterwards.
Okay.
My question is, for the whole panel, I was just wondering, what are your thoughts on Canada being able to meet the Paris Climate Accord commitments? Do you think that we'll be able to meet it, as well as still being so focused on pipelines in Canada?
That's a great question. So for rooms 74 and 64, the question is whether or not Canada can meet its Paris climate change commitments, its greenhouse gas reduction commitments, at the same time while pursuing new pipelines and oil sands growth. For the whole panel, who would like to start? Devon.
No.
I think that was deliberate. All right, this is continuing on my theme. So you would suspect that from what I've said, I'm pessimistic about our chances. And our leaders are not serving us well. There should be a byline to a movie, which is the boomers ate your planet and now they're leaving it burning in their wake. What are you going to do about it? But there's a couple of silver linings. The first thing is, a biologist who I respect says that we may be at the tipping point, but we're not past the turning point. And there's a couple of things that I take comfort in. That aren't going to be good for the tar sands, for example. One is that in 2020, the International Maritime Organization is going to mandate that you have to have low sulfur in your fuels. Tar sands fuel will never be used again for bunker fuel, and that's what's left over from a lot of the production. And the second thing is, you know what? I grew up in Saskatchewan. I was a car nut. I still am, as much as I try not to be, because transportation is 30% of our GHGs. Tesla had an amazing week, and there was an op-ed in, I think it was the Financial Post about 2 weeks ago, that said the current trajectory of electric fuel purchasing, which mainly is must be by the 1%ers, but anyway, electric vehicles are skyrocketing. Mercedes-Benz, for example, is transitioning completely out of diesel to electric. And all that those vehicles have to do is put a dent in demand to make Canadian expensive oil unmarketable. So yeah, it will happen. But you know what? It seems like it's going to happen in the absence of leadership. And I would say for those people in Fort McMurray, 75,000 people that are inevitably looking at the decline of their economy, ask your leaders to help you transition now.
I think this is the crux of it. Just will we meet Paris? Probably not be able to. Like Kyoto, we didn't meet. Kyoto, we went to Kyoto with a Liberal government, and we went with Al Gore negotiating, and we negotiated what the Americans negotiated, and then all of a sudden there's no Al Gore. We're facing George Bush and no Kyoto. We cannot compete with them economically. They will devastate us. We go to Paris. Barack Obama negotiates that. Now we got Trump. They're going to go to 14, 15 million barrels a day. We are going to, as Canadians, give away billions of dollars, like to the point of 25% of the UofS class won't get a job. There won't be money for health care and other things, and we're not going to make a dent in climate change because the world is still going to consume 100 million barrels plus. I have solar panels covering my entire roof. One of the other deals on climate change was Alberta phased out coal, gave subsidies for renewables. So I've got 1/3 of $25,000 worth of solar panels that make zero economic sense to put on my roof just to see how they work. There is I have studied Teslas inside out. I would have bought one with a huge Ontario subsidy if I could have got my hands on it. There's no way battery technology is there. Nobody credible will tell you that we can get off fossil fuels. How do you generate the electricity? I'm telling you from solar panels, you're going to need natural gas backup, you're going to need other things. We're going to have to go through ahead with Canada LNG. We're not going to get to Paris using LNG. So the issue is, how much do Canadians pay for the international cause? Because we will pay an absolutely massive amount that will make no difference whatsoever.
So I mean, I'm kind of my family's kind of a microcosm of this kind of debate. Both my brothers, my oldest brother made quite a good living in the oil patch. He left Ontario in the 1970s, and he started, I think it was Crazy Horse Logistics, and he's actually retired in Calgary. And I was a little scared that he was going to drive down here and pull me out of this panel. But so he was a millionaire. And first millionaire I ever known. My brother was also a pipe fitter, so he's gone across the country from Alberta to Ontario as a pipe fitter. So I know this. I hear this at family get-togethers all the time about the importance of pipelines. But we need to figure out how to do both. We need to figure out how to do renewables and how to curb the consumption of carbon. And that's really, really important, not just here in Saskatoon, but also to our brothers and sisters in the far north. My community, Couchiching, is an international water boundary that sees 50-year floods about every 7 years now. Our land is so soaked that we had to basically build a building on bedrock because we just don't have any land that's not just drenched with water because of the constant flooding caused by dams, but still, it's not called Rainy Lake by accident. It's got record rainfall. So I think that we need to figure out how to do both. And I think Indigenous peoples have laws and principles and values that can be shared through these consultation regimes that Canadians need to hear more about, because I think those values are important.
I just want one more comment. One way that we'd have a better chance of knowing that we could meet climate targets is to spend $4.5 billion on sustainable energy technology introduction and not on a tar sands pipeline.
Thank you. In the middle. Up there.
So we talk a lot about consultation with First Nations. I think that's great. I think that's part of it. But how do we bring consultation for all four of your perspectives into a room together? Because listening to what Professor Newman says, we have a federal court of appeal, and we seem to have all of these parties who have a giant stake in this not in the same room together. Is that part of the problem?
For rooms 64 and 74, I'm going to try and paraphrase what is a very good question. And I think that you'll correct me if I'm wrong, but the question is, how do we figure out how to get our governance and decision-making processes in Canada, not just judicial, but also at the government and the community level, to reflect the variety of perspectives that have been discussed during today's panel? How do we do that? Is that fair? And do we need to do that? Okay. At once. Who wants to take on that? It's a great question, because really that's what our climate framework was designed to do, at least on paper, but the evidence around us every day is that framework seems to be falling apart.
So one of the problems with the former regime under the 2012 legislation was that the Crown was absent at some really important times during a process. And I'm not a big fan of proponent-led regulation, so I think that's also part of the problem. And why we have these constant needs for do-overs is because the Crown is really not fulfilling its duty as a regulator, and has to have a better regime. Unfortunately, we went through this long process since 2015 to create Bill C-68 and Bill C-69. Some really great ideas from a really outstanding Indigenous consultation process. And rather creating a process that was a recipe for success, they cherry-picked as a menu and created a Frankenstein of a legislative bill. That's probably not going to work, unfortunately. And that's because the Crown is absent. Canada really needs to become a better regulator, and that will help these dialogues become more about whether or not a development is good or bad or in the public interest. And more importantly, whether or not it's sustainable.
I think people are on rooms on project-by-project basis, and the Indigenous communities, at least from my perspective, and that are affected by development of Alberta, have benefited. And I think Sara's talked about that as far as some people in our family are concerned, that goes across the board. But what governments, I think she's completely correct, are not. The industry has been accommodating employment as much as they can by way of economic benefits. But if there are true title, modern land claims treaties get you to more by way of economic benefits, and there has to be more economically flowing from the provincial and federal government to First Nations. There's not enough for industry to carry the load. So there has to be economic reconciliation from governments going to First Nations rather than dealing on a piecemeal project by project basis. There's a bigger solution where our Indigenous groups have more stake in the economic development than what they can negotiate on a project by project basis.
Let me start by making the question tougher and worse. On an optimistic note. So after the 2014 Silcotin decision in British Columbia, a historic decision that was the first ever judicial declaration in favor of Aboriginal title by a Canadian court, the expectations around Aboriginal title and what would be recognized are more divergent than ever before. And I think we heard today the perspective in terms of what would Indigenous laws say. That's going to have one answer. But thinking of just what the Supreme Court of Canada would say in terms of Section 35 law, a very well-respected Indigenous leader from Vancouver Island, Judith Sayers, gave the estimate that after the decision that it meant that 50% of British Columbia would be Aboriginal title land and would be recognized as such. Others, particularly in terms of on the government side, read it as much more limited and saw the Silcotin received 40% of their claim area, which was 5% of their traditional territory, and would read it then as maybe 2%. So there's the vast divergence of 2% of British Columbia to 50%. And I'm oversimplifying in terms of what these sides would say. That doesn't make it easy to negotiate a solution, but I think that's what also makes it necessary that there be talks the courts aren't going to solve it. And that's a tough thing to say to a room of aspiring lawyers. But we need people talking in communities and talking in all the different settings in which they can, to try to come to practical solutions where people can walk on paths together that work, as opposed to being left in the chaos that some of the judicial decisions leave them in, even while they're historic in other positive and constructive ways.
I think we have time for one last question. Sir. Oh, sorry, for the overflow people. So for rooms, attendees in rooms 74 and 64, the question essentially is, if the Trans Mountain Pipeline expansion project is so much in the national economic interest, why hadn't it been promoted by governments previously? Fair? Okay, very oil-friendly governments at that. Just add that in. Bernie, I'm sensing.
I know the answer. And I start out, Keystone XL probably would have made sense. That's what it's a market issue, right? So Keystone XL would have made sense to go first. Probably Northern Gateway would have been a better choice than Trans Mountain, in my view, if you'd have let the market decide, which is what the prior government tried to do, is let the market decide which pipeline was going to respond. The current government, what made it critical is, for political purposes, for the environmental agenda, Northern Gateway goes under the bus, maybe Energy East goes under the bus, we get rid of the coal industry in Alberta. In Alberta, we put on a 50-ton carbon tax to get the last one standing through. So I think the previous government saw the value in it. Usually the way we had made it work for 50 years before is the market decided what pipelines got built if they complied with all of the requirements. Northern Gateway, Keystone XL complied with all the requirements and were killed for political reasons. So that's why there are billions of dollars at stake here, and it is an economic crisis.
So I'm going to put a different spin on it. I think that, and maybe this applied to the Federal Court of Appeal, I'm being a bit facetious, but I think people in the halls of power are walking away from formal processes and looking at each other and going, this is insane. So let me just talk about one thing. You know, I don't think you have to have been to the tar sands to assess them. I was at the tar sands. I tree planted to pay my way through school, and I planted some of the reclamation areas, and then went back and planted the same areas a year ago, and because the trees all died. I don't think that makes me better able to assess it. If you assess the tar sands, you will find one of the most environmentally harmful productions on the planet. So tailings ponds you can see from space. So let's just talk about one thing that you guys are going to be paying for in the future. You're going to pay for reclamation. Because right now, the anticipated cost of reclaiming the tar sands, again, tailings ponds you can see from space, is $32 billion. How much does Alberta have in the reclamation fund? Anybody know? $1 billion. And do they have any plan to actually fulfill that account so that they can reclaim these things? And they have no technology to reclaim these toxic tailing ponds anyway. So what you're going to see is what we're seeing with the giant mine in the Northwest Territories, where now, when you guys all become taxpayers, a good portion of your taxes are going to go to pay $900 million a year to provide perpetual treatment of toxic water from a mine because there was no reclamation plan. That's the unfunded liability that we're facing here. So to answer your question, I don't know. I just kind of hope. I think judges now are going, I think they're starting to get more activist. The federal court is ruling in our favor far more than they have done in the past. And I think they're going to get in trouble at some point because people are going to say they go too far. But right now they're saying politicians aren't going to do what's reasonable. And one thing that you can count on in the courts, thank goodness, is you can have a fair airing of the evidence. You can't in a National Energy Board hearing. Lots of times we're fighting to cross-examine the proponent scientists. Lots of times we get denied. Science doesn't get a fair hearing. So I think it does in some halls of power, and I think they're going on the vast weight of the evidence. There's no way this kind of stuff should go ahead.
Okay, well, thanks very much. I'm going to call now on Elise Cruz, who's a member of the college's green legal team, all of whose members will not have trouble getting a job in the very green future, to thank our panelists.
A little bit of pessimism to close out. Thanks, Professor. As you said, my name's Elise Cruz, and I just want to quickly close this session out with a few thank yous. First of all, of course, to our panelists. Thank you for coming today and sharing your knowledge, no matter what it was. We as a community need to be more educated on this topic, and it's people like you that help us do that. So thanks a lot for taking that time. Professor MacLean, thank you for coming today to moderate for us. It takes a lot of preparation to get ready to moderate a debate. You have to really know the subject, so we appreciate you taking the time to prepare for that. I'd also like to thank some people who aren't quite as visible as our guests up here, but are just as important. And that's the College of Law staff and faculty that help put these panels on. They ordered that pizza that you guys enjoyed, hopefully. They got the panelists here. They do a lot of work in the summer to put this lecture series on, so thanks a lot to them. Professor MacLean mentioned it, but we'd like to thank McKercher LLP. We really couldn't do that, these entire lecture series, without their sponsorship. So it's really important, and we really appreciate them donating to us. And then finally, I'd like to take just a quick second to thank all of you guys as audience members for joining us. I know how busy you are as law students and just members of the community, but Professor Newman, I think it was you that said we have to have conversations about stuff like this to find practical solutions. So coming to debates and panel discussions like this help all of us be more informed when we have those conversations. So I hope you guys all leave here today and talk to your peers in your communities about the Trans Mountain Pipeline. So thanks a lot, everyone, and enjoy your afternoon.